two court judgments with legal and political implications were handed down in two of South Africa's senior courts yesterday. Firstly, the Supreme Court of Appeals upheld the December 2021 decision of the Pretoria High Court that overturned former President Jacob Zuma's medical parole. The SCA ruled that former Department of Correctional Services Commissioner Fraser was not supposed to overrule the parole board, and that the SCA ruled that Zuma must return to prison. And in another judgment, the Constitutional Court has granted Janusz Walus medical parole. Now, Walus is the surviving member of the duo that killed SACP leader Chris Hani. And handing down his judgment, Chief Justice Raymond Zondo said that Walus had complied with all the requirements, and a human rights lawyer and former CEO of the South African Human Rights Commission and chair of the Southern African Institute for Responsive and Accountable Governance, Advocate Tseliso Thipanyane, joins us now to help us unpack some of this. Advocate Thipanyane, welcome to Morning Live and thanks for being with us.
Good morning to you and to your viewers.
So let's start with former President Jacob Zuma's case. The former president was sentenced to 15 months for failing to obey a court order to appear before the Judicial Commission of Inquiry into allegations of state capture. He was then subsequently released by the former DSC, the Commissioner Fraser, on medical parole after serving less than 2 months of that sentence. So what is your view on the outcome of that case, first and foremost?
Thank you. The outcome is actually very important as far as the rule of law is concerned, and the need for those who exercise public power to do so in a proper manner, as well as, of course, the principle of equality before the law, that all of us are equal before the law, and the law must be applied equally. So it's a very important contribution in the jurisprudence of enforcing and enhancing the rule of law in our country, and also sending a very clear signal that public officials must act accordingly.
So if we look at that verdict, it says that a parole must be lodged in a prescribed manner, goes on further to list the requirements to be fulfilled which were not met. For example, one of the requirements are a complete medical diagnosis and also, excuse me, prognosis of the terminal illness or physical incapacity from which the sentenced offender suffers. But instead, in this instance, the medical report, according to Dr. Mafa, stated that Zuma has several comorbidities. The former president later told a journalist who asked him about his health whether he looks like a dying person. So, you know, you listen to all of this, you look at how everything transpired. What is to be made of these issues, notwithstanding that they go beyond legal into the political realm as well?
It is a concern because, you know, the medical parole basically rejected the request that Mr. Zuma must be released on medical grounds, which then shows that, you know, the earlier report by the doctors was not correct. Hence, it was rejected. But more importantly also is that the commissioner then ignores the recommendation of the medical parole board, which actually has to be complied with as the court has ruled. So again, it highlights, you know, one of the challenges in our country, that public officials sometimes act outside the law. They don't act in the interest of our country and the rule of law. And hope this court decision actually is another reminder that all of us have to respect the Constitution. We have a principle of supremacy of the Constitution and the rule of law. We have to respect the laws of our country.
Indeed, we do. But of course, also just looking at, you know, how far-reaching this particular judgment is in terms of also just determining the powers of the Commissioner of Correctional Services when it comes to actually granting parole to those who may be eligible or not. So in just speaking to that particular issue, you know, the court, of course, has said that the commissioner must now decide whether the time spent by Zuma was actually should be taken into consideration in determining his sentence. So let's talk about that, Advocate.
Well, this is also another important position there, where the court said, you know, in reversing the decision of the High Court, that the courts themselves must also stay within their lanes, because we have a principle here of separation of powers, and therefore none of the branches of government should really stray into the other one without justification. So the court said the rule that the High Court's ruling cannot apply. The Commissioner of Correctional Services, who has the power in terms of the law to decide on these things, must be the one deciding. Because if you recall, the High Court had actually said that the term Mr. Zuma has served should not be taken into account. But the Supreme Court ruled that that's actually an overreach by the judiciary.
So, Advocate Thipanyane, also just in terms of, the time that the former president did spend, and as we say, the commissioner now needs to decide whether he should, in fact, return to prison to serve out a little more of that time or not. But that sentence obviously lapsed a few months ago. So what sort of impact or bearing does that have on where this particular situation finds itself right now?
Well, the Supreme Court has ruled that the decision to release Mr. Zuma on parole is unlawful and unconstitutional. It doesn't count. However, the discretion still applies with the National Commission of Prisons, Correctional Services, to determine, how long Mr. Zuma must then stay in prison in view of the fact that he spent already 15 months outside. So that is at the discretion of the National Commission of Prisons. Unfortunately, however, if he makes a wrong call, the matter will again be taken on review, because public officials must exercise their powers responsibly in a rational manner as well. So it will be up to the National Commissioner of Correctional Services as to how he will then apply his mind in view of the decision of the court that, the term outside by Mr. Zuma was illegal and unconstitutional.
So when you say if he makes the wrong decision again, what would the wrong decision be in this instance?
Well, whether he exercises his powers in a rational manner and a fair manner. So the courts, at the end of the day, are the ones who decide as to whether public power has been exercised in a proper manner. And therefore, they will look at the reasons, what informed the decision of the National Commissioner of Prisons, of Correctional Services, to release Mr. Zuma after a day or two, a week or 6 months. Time will tell. But one hopes that, the message has been sent very clear to all public authorities that you have to act within the parameters of our law and the Constitution.
And, we touched on the fact that there are political implications and ramifications as well. Having seen what happened after the former president's imprisonment in July last year, Arthur Fraser, the commissioner at the time, saying that he was afraid of some of these political ramifications. So looking at these political implications, again, should those have any sort of bearing in terms of the decision that the commissioner finally arrives at?
Well, we cannot ignore the context of our decisions as public bodies. However, the Constitution is very clear that we are bound by the rule of law. We are bound by what the Constitution says and the law says. So we do have to apply the laws accordingly. And as you saw in the case of Mr. Arthur Fraser, the court actually said he must pay costs of the application. And this should also send a clear signal to public servants that, you can't make wrong decisions and waste taxpayers' money because you are acting out of other interests and not the interests of the nation. So yes, at the end of the day, laws are meant to serve our nation, and laws must be exercised in that context, not for partisan interests, which basically then undermine many things.
Brings us to the next big story yesterday and cases before the courts. What was your reaction on the release of Janusz Walus? Constitutional Court ordered that he should be released within 10 days.
It's definitely a difficult decision. I was young when Chris Hani was killed in when I was in Pietermaritzburg, and I saw the anger of our people there. So yes, the death of Chris Hani has definitely been a major, major trauma for all of us. And I guess one understands, why people are reacting in this manner. However, unfortunately, the law is very clear. We have to act within the law, and parole is part of our legal system. And the courts have ruled that in this case, Mr. Walus, after spending 28 years in jail, does deserve to be released on parole. Of course, if the Minister of Justice is not happy with the decision, he can go to the African Union through the African Commission, African Court to challenge this. But up until then, the decision stands, unfortunately, whether we like it or not. Now, but we also have to bear in mind that there have been other people who have been released on parole, like Mr. Eugene de Kock. One didn't see such an outcry. But of course, one has to understand that, people are upset and people are pained about, the assassination of one of our leading lights, someone who probably have been the president of this country, someone who actually committed his life to our democracy and freedom. So yes, people will be angry, but at the end of the day, we still have to respect the court. So it's actually unfortunate that, disparaging remarks were made about the court, that the decision is diabolic and stuff like that. Yes, we will not always agree with the decisions of the courts, but, as a democracy, as a constitutional democracy, we have to respect the decisions. And if we disagree with them, there are mechanisms in which we can address those differences in a respectful manner, because we do have to support and respect our constitution, our constitutional court and courts, because they are very central to our democracy and the rule of law.
And that's an interesting point, because when the widow of the late Chris Hani, says this was a diabolic decision by the court, the SACP says it's an injustice, those are obviously real feelings that are being expressed, feelings of frustration. People have been feeling that they have been let down by the judicial system. How much of a consideration are their feelings, the feelings of family, of loved ones, when it comes to releasing people on parole?
Well, our constitution is a social contract between all of us as South Africans, defining and shaping the South Africa we want. And these are the laws which have set in place, institutions have set in place, and sometimes we don't always agree with them. I mean, you might recall many years ago, the Constitutional Court made a ruling against Dagga, and some of us were not very happy about that. Mr. Prince actually went to the African Commission to complain, he lost, but later the Constitutional Court made a different ruling. So yes, the court sometimes will not get it right, Parliament will not get it right, government will not get it right, but we have to deal with those differences within a proper paradigm. We don't have to go and say courts are diabolic, stuff like that. Despite our pain and our rejections, or our refusal of the non-acceptance of the decisions.
So I think many people struggle with that in terms of why can't someone say it's diabolic? Why can't someone strongly disagree with the decision of the courts? Why are people not to say things like that against, the courts? Why not?
Well, the Constitution is very clear that the courts, our judiciary, must be respected. All organs of state must do everything to ensure that the courts are independent, they do their work without fear or favor, and that we don't interfere with them because of the role they play in ensuring that, we maintain the South Africa we want. So even if we disagree with them, there are parameters in how we disagree with their decisions, and not just insult them. So basically, to insult the courts goes against the Constitution. And if we say the Constitution is actually supreme and the rule of law is supreme, then we do need to tone down a little bit. So one might understand from ordinary people, but for people who have been members of parliament, members of part of government, definitely we should be able to, be more measured in our criticism of the court, in view of the role they play, in view of the support of our constitution. This constitution was actually done by us as people of South Africa. It's our constitution, and we can change it if we don't want it. But as long as it's there, we must respect its provisions and its principles.
So, Advocate Thipanyane, and I think that's a very important point, because we hear that quite a lot, about showing respect for the courts and, having to be measured in our criticism, as you put it. But how then do you actually go about criticizing and critiquing judgments of these courts?
Well, one easiest way, you appeal against the judgments. Secondly, academics can write, politicians can write about those judgments. You're allowed to criticize the judgments of the Constitutional Court or any courts. You can even say you disagree with them. You can say that the courts didn't apply their minds properly. but you do not insult them. There is an element of fair criticism which is allowed. Then the other issue we need to
But
bear in mind.
what about lay people? You say academics can write, politicians will have their avenues, but what about lay people? If they feel aggrieved about a decision by the court, how do they go about expressing their displeasure at those decisions?
Well, first of all, we should actually do more education in our country for people to understand, what is our constitution and what the courts mean in our lives and how we interact with those courts. So definitely there will be an element of measure and understanding from the reactions of ordinary people who might not fully understand the importance of respecting these bodies. But as we go higher up, there's a need for higher accountability and responsibility. That's why, for example, you can't expect the president of the country or ministers to go about insulting or swearing judges. They should know better. So yes, there is a measure of understanding for ordinary people, but it is important that we respect these judges, because the moment we lose respect for our courts, then what's going to happen? There will be chaos in our country. It means everybody does whatever they want. Survival of the fittest. That's not democracy.
We unfortunately have to leave it there, but I think we should pick up the conversation at that point where you talk about the education that needs to happen. Who's supposed to do that education? Where is it supposed to happen, etc. But we have to leave it there for now, Advocate Thipanyane. But thanks so much for speaking to us. Former CEO of the South African Human Rights Commission and Chair of the Southern African Institute for Responsive and Accountable Governance, Advocate Tseliso Thipanyane, giving us his legal views on the two court judgments that were delivered yesterday.